Good morning, everyone. I'm Jeff Gray. I'm one of the employee benefit lawyers here at Miller Johnson. Thanks for joining me early this morning for a brief webinar to cover recent changes in the law that affect retirement plans. We have a few topics to cover today, including changes that were made by the most recent federal stimulus bill and some recent guidance from the IRS and the Department of Labor. The first item to talk about is one of the most recent changes under the Consolidated Appropriations Act of 2021. This, of course, is the most recent federal stimulus bill that was signed by the president there at the very end of last year on December 27. This bill, I think, thankfully, does not have a tremendous impact on retirement plans. Really, there are only a few, I would say, relatively minor provisions that affect retirement plans. But one of the most important, though, of the handful that affect retirement plans is this this sort of pause on the partial plan termination rules for 2020. I did a webinar that was really solely devoted to partial plan terminations, I think in November or December last year. So we really tried to emphasize this. And of course, at the last minute, Congress changed the rules on us. But for a little background, for those of you who may not be familiar with it, a partial termination of a qualified retirement plan happens whenever there's a significant percentage drop in the active participants in the plan due to some sort of employer-initiated event. That significant percentage is generally 20%, although it sort of depends on the circumstances. And when that happens, the affected employees must be made 100% vested under the plan. So this, of course, doesn't apply if you're a safe harbor plan. It also doesn't apply if you have a 403B plan, but it does happen from time to time for other qualified retirement plans. So if we take an example here, if you had a reduction in force in 2020 that resulted in a 20% drop in active participants, you may have had a partial termination of the plan in 2020 under the normal rules. And we had kind of emphasized that it's good to catch that when it happens because it's difficult to, it's not difficult, but it could be expensive to correct a partial termination in a later plan year when you find out about it. So I think, some employers who knew that they were laying folks off and weren't doing rehires in 2020, they may have acted on this and actually vested people under these partial termination rules. Under the Consolidated Appropriations Act, though, there's a provision that says we're basically going to ignore these partial termination rules during this particular period of time in the Act. So between March 31 in 2020 and March 31, 2021. In other words, even if you may have had a partial termination in 2020, and again, this partial termination determination is sort of made on a plan year basis usually. So you look at the end of the year, whether you had enough of a reduction to trigger one of these terminations. I think Congress was worried that a number of employers who weren't paying close attention to this could have had a partial termination last year and wouldn't even know it, and that could cause a real problem. So under this provision of the Act, it basically moves the partial plan termination decision until March 31 of this year. So basically what you do, as long as you comply with this rule, you won't have to worry about a partial termination last year. And the rule is basically if the number of active participants in your plan as of March 31, 2021 is at least 80% of the number of active participants as of March 31, 2020, then you don't have to worry about having a partial termination during that period of time. So I think that's good news. I think that will protect employers who maybe weren't even aware of these rules to some degree, especially if things turn around a little bit and there are fewer lockdowns by March and maybe there's some rehiring, particularly by the restaurant industry or the hospitality industry before March. I think it's going to be a little bit difficult, though, if you're one of the employers who was on the ball last year and maybe vested folks because a partial termination happened. I don't know that there's a way to unring the bell in that circumstance if you've communicated it, or if people have taken distributions. I suppose if you've vested some people and maybe it's just a change in the record keeping system that you need to make to undo that, that may be okay. But if you've actually processed a partial termination and vested people, I think you'd want to talk to us before you do anything to try to take advantage of this new provision in the Consolidated Appropriations Act. So that's one of the major changes. The Consolidated Appropriations Act also includes a number of disaster relief provision that's similar to other provisions. The coronavirus related distributions last year were really based on these disaster provisions that we've had in the past, in previous examples of hurricanes. The idea here is that there's some similar what are called qualified disaster distributions in the event that you are a participant with a primary residence in a disaster area. It's important to understand, though, that these are federally declared disasters that are unrelated to COVID-19. So we've seen in some news reporting that this act basically extended the coronavirus related distribution relief, and that's not true. Those distributions ended the end of last year. These provisions are limited to federally declared disasters that are declared between January 1 of last year and February 25 of this year. And so if you think about it, they're structured similar to coronavirus related distributions of last year under the CARES Act, but those distributions were for people who were qualified individuals under the CARES Act. So they tested positive for the coronavirus, or someone in their household, for example, tested positive. These are more related to some sort of hardship that you would have had because your residence was in a disaster area. And that can come up in the context of wildfires in California, for example, or Hurricane Laura. And again, these are optional for a plan to add. You're not required to add these disaster relief provisions. They work similar to the distributions under the CARES Act. So a participant, if you were to add these, could receive a distribution of their full account balance up to $100,000. They could also repay hardship distributions that they may have taken out to purchase or build a home in the disaster area. So if you took a hardship out to build a home and then it was ravaged by some sort of wildfire, this provision lets you repay that hardship distribution to the plan without any tax penalties. You can also delay similar to the CARES Act, delay repayment of loans, and there's an increase in the availability of loans up to $100,000 or 100% of the vested account balance, rather than the standard rule, which is $50,000 and 50% of the vested account balance. So again, these are optional provisions, but if you're, and they really don't impact anyone in Michigan because we haven't had a federally declared disaster that's not related to COVID-19. So, but if you've got other operations in California or some of these other places affected by hurricanes, maybe this is an option you want to consider. The deadline to amend the plan to add this, if you want to, is the end of the plan year that begins on or after January 1, 2022. So you've got some time, just like the Secure Act and the CARES Act, before you need to amend your plan to add this provision. There are a couple other, I would say, minor points in the Consolidated Appropriations Act related to retirement plans. One provision basically retroactively amends the CARES Act to allow coronavirus-related distributions from money purchase pension plans. We don't see many of these money purchase pension plans anymore, but it was a little bit unclear under the CARES Act how it worked with those plans. So this act kind of corrects that lack of clarity and retroactively amends the CARES Act to allow those distributions. Now those distributions they've ended by the end of last year. So you couldn't get a new coronavirus related distribution under a money purchase pension plan. But if you took a distribution from one of those plans last year that would have otherwise qualified as a coronavirus related distribution, you could get the tax benefits from that by virtue of this provision in the new law. There's also, I think, a really obscure provision, at least from my perspective, that relates to overfunded pension plans that have elected to transfer certain excess funds to a retiree health account or retiree life insurance account. There's a provision in the tax code that lets you sort of take that overfunded amount and in the future transfer it annually or transfer it in part over 10 years into another health account, kind of take advantage of that overfunding. There's a rule in this Consolidated Appropriations Act that basically lets you terminate that transfer early. And if there are funds that were previously transferred into this other account that haven't been used under this retiree health account, you get those funds back as the plan sponsor, and you can basically use them without penalty as long as you put them back in the account within 5 years. If you fail to do that, it's treated as a reversion, which is subject to additional taxes. I think it's an additional 50% tax on the amount. So I'd be surprised if anyone on this call is in this situation at all. If you are, let me know, because I'd be shocked. So that's really it. I mean, the good news is, we hear rumblings that there are more retirement plan provisions in the latest stimulus bill, and you think, oh, great, what's going to happen now? What's going to be the big change? And there really wasn't, just some minor changes for retirement plans. And I think that I feel good about that. I don't know if you do either, but there's just so much change. It's nice that there wasn't anything earth-shattering in that act. Let's see. So there have been a few, even in 2021 already, 3 weeks in, right? We've already got some more guidance from the IRS. This, though, is pretty simple. Last year, you might recall, if you have a pension plan or another plan with annuity payment options, there's a requirement that spouses consent to a participant's election of any other payment option besides the joint and survivor annuity. So if a participant with a plan like this wants to take a lump sum, the spouse has to sign off on that. And what we ran into last year, especially in the context of terminating pension plans, you basically have all these participants who have to make a decision about how to take their distribution. And so you could have hundreds of people or more who need to get spousal consents, and the banks were closed. So what do you do? So the community generally pushed the IRS to allow those spousal consents to be witnessed remotely. The IRS, without really any support in the statute, in the relevant statute, has always required this witnessing to be done in the physical presence of a plan representative or notary. So when the spouse needs to do this consent, it has to be witnessed by someone. The statute says witnessed by one of two people, either a notary or a plan representative. And in the past, at some point, the IRS said, well, we think Congress means witnessed in the physical presence of one of those people. And that physical presence requirement became, like I said, a real tricky thing to navigate around last year. But we did get some guidance from last year that said, okay, we'll give you some relief from this physical presence requirement until July 31, 2020. You can basically you can witness these consents remotely. And the rules for those remote consents, it's basically as long as you are following the state law that relates to the witnessing, the remote notarization of a document, you're okay. So Michigan, for example, has a set of rules for notaries for notarizing things remotely. And I think the governor last year issued some rules about that as well. And then the notice itself from last year provides the requirements if you actually have a plan representative who's witnessing these sorts of consents remotely. Both situations require a kind of live audio video technology. And then there are a number of other requirements that go along with it. So if you're doing, the point with this slide is that this relief has been extended. And if you are actually in the situation of doing remote notarization or allowing participants to do these consents, these spousal consents remotely, just be aware that you want to check these state rules about remote notarization to make sure people are doing it correctly. And we also have a client alert on this, I think, from last year that lays those rules out in a little bit more detail. So if anybody actually wants those, just let me know. I can shoot you that client alert that we did. We also have, this was a rule that the Department of Labor issued, I think in October last year. So this is a new, not new, but a rule that's final based on the plan sponsor's fiduciary duties when it comes to selecting investments for a retirement plan. This has been kind of an ongoing issue, but this relates to selecting investment based on what are called selecting investments that are based on what we're referring to as environmental, social, or corporate governance factors, or ESG. And this has been going on for quite a while. Basically, what happens is, and I've heard this in retirement plan committees from time to time. You'll be there with the retirement plan committee, and somebody will say, "Well, you know, we are in the you know, whatever it might be, the alternative energy sector of the financial system. So we don't think we should have any funds in our plan that include stocks of oil and gas companies, for example, and vice versa. Maybe you've got an oil and gas company that says, hey, we don't want any of these alternative energy stocks in the lineup for people to invest in because they're our competitors. Or I've had situations where maybe you had a kind of religious organization or order that was more pacifist in nature, and they were just absolutely against having any sort of funds with defense contractors in them. You can think that there's many ways in which a retirement plan committee might say to itself, you know, we just don't want to support this particular group or this particular idea. The problem with that is that ERISA has baked into it a clear fiduciary obligation to act solely in the best interest of participants. And the Department of Labor's emphasis here is that obligation really means you as the plan sponsor need to be selecting funds based on their financial returns, based on what the DOL refers to as pecuniary factors, you know, not these other factors outside the scope of how will these investments work in terms of providing retirement funds for employees. That has to be the focus. We can't subordinate kind of the financial aspect of these funds to other objectives that a committee may have. This got a lot of pushback from a lot of people. I think there were something like 7,000 comments that came in on this rule, but it's a final rule. There is a situation where you can use these what the DOL refers to as non-pecuniary factors, but it seems like it's a big hurdle to meet. If you have two kind of equivalent funds that, based on the normal investment sort of guidance, are kind of the same. So we've got two funds, the pecuniary factors sort of work out the same. Well, in that situation, maybe you can rely on these other objectives or these other environmental or social aspects. But you have to go through this process of documenting why these funds are basically the same from a financial perspective, and then also document all of the other factors that now you're relying on besides those financial factors. And it just seems like it's kind of a trap. I think it's going to be difficult to do, but it's possible. And I don't really, this stuff, the financial advice makes me sort of, my eyes glaze over. But when you're in these meetings, the financial advisors talk about things like Sharpe ratios and up-down capture. They have all these, to me, seem like complicated financial measurements, but the focus here is to focus on aim at those objectives and not these other objectives that may come up. So the next piece of guidance, again, came out late last year. This just clarified this IRS Notice 2020-86, clarified certain aspects of the Secure Act related to safe harbor plans. As you may recall, under the Secure Act, non-elective safe harbor plans no longer have to send out a safe harbor notice, either annually or to new participants. A non-elective plan is a plan that basically you're contributing a safe harbor contribution based on the participants' compensation, whether they defer into the plan or not. So we compare matching plans, plans that have matching contributions and plans that have non-elective contributions. This change in the notice requirements only impacts non-elective safe harbor plans. So this notice 2020-86 just clarified that, hey, there are some other notice obligations that still exist. Of course, even if you have a non-elective safe harbor plan, you still have to send out this automatic enrollment notice if you have automatic elective contributions. And what's called an EACA, or an eligible automatic contribution arrangement. In those plans, participants can take out their automatic deferrals within 90 days. That type of plan has a particular notice that goes with it. So all the auto enrollment notices, those still stay in place, even if you have a non-elective plan. And also one issue that came up last year, as we were kind of debating what to do about this, if you're non-elective safe harbor plan, you don't have to send out this annual notice. But there's a requirement that if you are going to suspend your safe harbor contributions in the middle of a plan year, you can only do that in two situations. One, where you're operating at an economic loss, where the business is operating at an economic loss, or two, that in the safe harbor notice that you sent out, that you explain to participants that the safe harbor contributions may be reduced in the middle of the year. And so our thought was that, well, if a non-elective plan doesn't send the safe harbor notice under the Secure Act because it's not required to anymore, are they going to lose the advantage of that provision, that other provision in the code that allows you to reduce or eliminate the safe harbor contribution mid-year? And our thought was yes, that you still need to send the safe harbor notice out if you want to preserve the ability to suspend or reduce safe harbor contributions mid-year.
This IRS Notice 2020-86 confirmed our suspicions, which is that yes, if you still want to preserve that ability to suspend your safe harbor contribution mid-year, you should send out the same type of safe harbor notice that you've been sending out, even if you're a non-elective safe harbor plan. All right, let's go to the next slide. This is just a slide to remind folks that there are some different timing requirements for these changes in the required minimum distribution rules under the Secure Act. So we know that the Secure Act increased the age at when these minimum distributions have to begin from age 70 and a half to age 72, and that generally applies to participants who turn age 70 and a half after December 31 of 2019. So, but then there's a different rule that talks about that it basically accelerates certain post-death requirement distributions for defined contribution plans. So in the past, you could kind of spread those post-death required minimum distributions out over the joint life expectancy of the participant and the beneficiary. The Secure Act limited the number of situations in which you can do that. So surviving spouses, you can still do that. Some minor children or disabled folks, there's some exceptions where you can still kind of stretch those post-death required minimum distributions. But outside those situations, the general rule is that the full payout has to happen within 10 years of the end of the year in which the death occurs. But for whatever reason, there are a few different effective dates for this provision, and we just wanted to mention it. For private or private employers, this rule applies to deaths that happen after December 31 of 2019. But if you have a collectively bargained plan, there's a kind of delay at work there. So the general rule is this new rule applies to deaths after December 31, 2019, or the expiration of the current collective bargaining agreement if that expiration date is later. But the kind of final drop dead deadline for this is December 31 of 2021. And then governmental employers, this new rule applies to deaths that happen after December 31, 2021. So depending on which group you fall in there, you'll have different effective dates for this post-death required minimum distribution requirement. This is just, again, a reminder to employers that if you have a pre-approved plan, those pre-approved IRS plans are still on the 6-year cycle for restating for legal compliance. The latest third cycle started very recently in terms of so there's the kind of 4-year period at the beginning of the 6-year cycle where these plans get submitted to the IRS and approved, and then there's a 2-year period at the end when the employers actually have to review and sign these plans. So that 2-year period started last year in the summer on August 1, and so then this 2-year period extends until July 31, 2022. So you've got a little bit more time here, about a year plus, to review and sign any restated plan documents. So you'll get if you use a kind of off-the-shelf plan from Principal or Fidelity or whoever it is, they will be sending you a restated plan to sign soon. If you use one of Miller Johnson's pre-approved plans, we also are ready to restate that plan. We're in the process of restating many right now because it's a process, and honestly, July 31, 2022 will be here before we know it. So it's good to get going on this. Get your plans reviewed, restated, and signed by that deadline. There's also, if you have a purely individually designed plan, it may be a number of years since the IRS approved that plan. There's no longer an approval process for individually designed 401k plans, for example. So if it's possible to put that individually designed plan on a pre-approved format like the Miller Johnson format, now would be a good time to kind of explore that possibility. So that was just more of a heads up. And that's all. Thanks for joining me. And if you have any questions on any of these points, please let me know.